May it please the court. I want to cut to the chase on this matter and go right into what 514F.2 means, at least as far as my understanding of it. What happened was that the House of Representatives handled HF 2219 first, and everything that's in 2219 other than Section 10 was decided upon in the House and then brought to the Senate. The Senate Commerce Committee basically had passed the first part of 514F, and as I first saw it, that was the proposed amendment, and it was clearly sponsored by the Blue Cross Blue Shield and the Iowa health insurance companies. Their lobbyists were there, and so it, contrary to what the insurance commissioner says, it had to mean something. And I'll submit that what it means is it's not a regulatory matter, that first part. It's a deregulation. It says that with respect to these various systems that whereas these people can contract with providers for like preferred provider contracts or capitated payment systems or other systems, that they have the right to do that, and there's nothing in the insurance chapters that prevents it, nor regulates it. Now, it's substantive in the sense that it gives insurance companies, HMOs, et cetera, the authority to enter into contracts with providers, that is hospitals and various different health providers. It gives them authority to do that without any regulation whatsoever. It was handed to the chiropractors in the back of the Senate, and the provided part was added with the consent of the Blue Cross and the insurance companies, and then it went to the floor of the Senate, was passed, and that's where the bill stands. Now, what our grievance is that chiropractors are paid approximately 50% of what MDs and DOs are paid for evaluation and management. That's diagnostic type things. 70% of what is paid for x-rays, and about 75% of what osteopaths get for the same spinal manipulation, or same manipulation would be of other members other than, of course, the back. And we say that is contrary to what is said in the provider section. And in particular, Steve, can you help me? You have to go to related to the license under or practices authorized by Chapter 151. After the case of State versus Van Wyck decided by this court in 1982 against the chiropractors patients were up in arms, particularly in the rural areas, and a new chiropractic bill was passed in the 83 legislative session. And in particular, the definition was changed dramatically from what the definition was before, to what adjustments of the neuromuscular, most musculoskeletal structure through various devices, and in particular, item 3 set forth particular acts or conduct that is authorized by the legislature. Now, I contend that one has to read that in context with 151.8. There's a case in Iowa in 1964 called Correll versus Goodfellow. It's 125 Northwest 2nd 745. And what that case held, and this has to do with the modalities, is that if it was ultrasound was the problem. They said it was outside the scope of the license of chiropractors, and therefore, if you use ultrasound, you're held to the standard of a medical doctor. Well, in 1974, legislature authorized modalities, and number 2 here has to do with the provisions of how the standard of conduct, and they have to exercise the care which is common to physicians in this state, which is what Correll versus Goodfellow said, but for different reasons. And then, in 1983, when number 2 and number 3 of 151.1 were completely redefined, there was a third section added to 151.8, saying chiropractor using additional procedures and practices authorized by this, it used to be act, now it's chapter, shall be held to the standard of care applicable to any other health practitioner in the state. Much broader than just held to the practice of an MD or a DO, but he's held to the practice of anybody that's a licensed practitioner. Now, if you now go back to this phrase in 114F2, it's rather clear what license under a practice authorized by Chapter 151 says. And it says, essentially, that the practice of chiropractic in any of its facets is held to the standard of MDs and DOs, plus. Now, that is the clearest possible statement of legislative intent you could have as to what they meant. And they meant that chiropractors, if these people were going to start being able to do PPOs and all that sort of stuff, they were going to treat chiropractors equally because they're held to the same standard as the MD and the DO.
Norris, I think I follow your argument pretty well with respect to chiropractors when they're paid on a fee-for-service plan. Your argument being that you can't, under that statute, pay a lesser amount to chiropractors for the same service.
Yes.
But a lot of this case, as I understand it, involves this Wellmark HMO plan where they set up this ICPC, and then ICPC pays the chiropractors. And my question is, what in the statute prohibits having a capitation system for one group of health providers and fee-for-service for another? How does that violate the statute?
Well, this section here says unless you treat them equally, because they're held to the same standard. Unless you treat them equally, you have no authorization to do any of this stuff. They can't even have an HMO that does capitated payments or anything else unless they treat chiropractors equally.
the language is limit or make optional payment or reimbursement. It doesn't say you can't have two different payment systems, which is at least Wellmark's argument with respect to the HMO plan.
Well, I'm not particularly hung up about capitated payment versus PPO. I'm particularly hung up by the fact that our people, number one, there's a very limited number in the group as opposed to what Wellmark does with anybody else. Most Wellmark's other HMOs to everybody else have more people in it than the PPO as far as providers. Secondly, they don't get paid. They get paid less than half, far less than half of what MDs and DOs are getting. Or as far as that goes, what nurse practitioners and physician's assistants and physical therapists are getting. This simply says that you can't, because the law holds them to the same standard, that they can't be discriminated against in payment. Now, as far as whether you can have a capitated payment system and a PPO, I suppose that would be just fine as long as they didn't get discriminated in payment. Am I tracking with you? Okay.
Counsel, what deference, if any, should we give the insurance commissioner's interpretation of the statute it administers?
Well, number one, I don't think the insurance commissioner knows anything about what's in Chapter 151 or what chiropractic is. They certainly didn't demonstrate any ability to know it. I don't see how you can say that that's in his particular expertness. Now, as far as what some of these things are up here, I wouldn't quarrel with you by saying that might be something the insurance commissioner might know about more than, say, a court or the average person on the street. But that's not what we're talking about. Am I answering you?
Yeah, and can't we rule in your favor, in your client's favor, based on the plain meaning of the word limit? It seems to me if you're paying one licensed practitioner less for doing the same service, that's limiting.
Well, I think so.
And that's prohibited, right?
Not only that, but I think Justice Mansfield in the dental case says precisely that. So, yes, I agree with you. And I don't know. The problem is that Wellmark's basic contention is that they have the right to pay chiropractors less because they're trained less, they perform things faster or not as fast or whatever. And I mean, that's well and good that they think that, but the legislature has preempted that whole idea.
What about the language on the basis, or solely on the basis of licensure?
Well, number one, of course, I've cited a case on that. In the Iowa Supreme Court case that rather clearly says, you know, if it has, in our case, if basically what you're focusing on is chiropractic, it doesn't make any difference whether you focus on their education or their training or whether they can jump 3 feet or not. Every criteria that they're stating in the record, Wellmark states in the record, has to do with being a chiropractor. It just, there's no way to get around it. And if indeed all of the criteria they're using differentiates and discriminates against chiropractors, then they're basing the discrimination solely on chiropractic, or the licenses and the practices. It just, I mean, if you can find something else that would indicate that they're looking at something other than chiropractic in setting their fee structure, yeah, I would go along with you on that. There isn't anything. It's all about chiropractors. I'm under the wonderful, I suppose, ability to say that I'm quitting before the time's up, because you guys have really come right out and asked the pertinent questions, in my opinion, and I hope I've given you the answers that you're looking for.
Could I ask one more question, Mr. Norris? You did use the word preemption, which brought to my mind I read, I guess, the U.S. Supreme Court's most recent pronouncement, the Gobet case, dealing with self-insured plans, and it does suggest that there's a fairly broad ERISA preemption as to self-insured plans.
I have no doubt that you're absolutely right on that, because it's anything that relates to it. Yes,
right. And so my question to you is, why doesn't ERISA preemption apply as to those employers offering self-insured
I have several answers here. I'll try to rattle them off as fast as I can, all right? Number one, we don't have the burden of proof on that issue, and they didn't make any record on it. They didn't put a single plan of a self-insured into evidence to show what it was. I suspect that almost all of the plans have a copay of $1 amount. If that copay is of $1 amount, then nothing involved in what's being paid to the provider has any effect on the plan, on what the copay is. You're going to pay $10 or $15 or whatever, no matter what. And in that situation, the Department of Labor, who's in charge of this statute, says that there's no preemption. It simply doesn't apply to provider contracts. I cited several cases at the end of the, I don't know where it was. I cited several cases. They're citing cases that have to do with any willing provider. And those cases seem to say that requiring any willing provider to a ERISA plan affects it in some way as to administration or something or other. But we don't have that. We have a direct contract action. That's what I say we have. We have a direct contract action that they're breaching their contract, particularly if 514F.2 is incorporated under Cornick versus Southwest Iowa Broadcasters, which this court has said it should be. So our situation is one where we're actually suing for breach of contract, and the case law on that particular thing says that there's no preemption. That's really fast. Okay, thank you very much.
Thank you as well, Mr. Norris.
Mm-hmm.
Mr. Koopmans.
Thank you, Chief Justice. May it please the court. I am going to take the first 10 minutes, or at least I'm going to try to sit down in 10 minutes and reserve the remaining time for Ms. Esbrook from the Insurance Division. This case, as you all know, has a history. It really is a child, I guess, an offspring of the Mueller case that came out of this court, an opinion by Justice Waterman, which said that there is no private cause of action under 514F2, and thus this court told the chiropractors to go talk to the Insurance Division about that. That happened in the form of a contested case request, and then this case, and before the Insurance Division, proceeded, at least at first, as a contested case in front of an ALJ, and a full-blown trial, a 3-day trial in which experts were called on how Wellmark sets its fees, why Wellmark sets its fees the way it does. And then eventually it came up to making all the legal arguments in between that you have in your briefs, came up to the insurance commissioner, and he made a very good point, which is to say, why is this a contested case? I don't believe it is, nor it can be. This division is not a private adjudicatory body. We, the insurance division, brings charges, and then we adjudicate those charges. This is not a place to bring a breach of contract action, as Mr. Norris said. So now what we have here today, what this court is reviewing, is a DEC action. The insurance commissioner, which I think properly, converted it into a question of what does this statute, 514F2, mean? And then went through and proceeded to decide exactly what that means based upon the facts that had been found by the ALJ on the factual side, and then as a legal matter, what 514F2 means. I give you all of that history because I think this case gets a little confused because of how it started and now as how it changes, how it comes to you, because The record is huge. We have an administrative record that is thousands of pages long. The appendix, I think, is well over 1,000 pages long. But really, and we have made multiple arguments, but it comes down to one, and I really think it is that simple. 514F2 does nothing by itself. It is an interpretive provision only. It starts out like dozens and dozens of statutes, interpretive statutes, start out with in the Iowa Code, which is nothing contained in the insurance chapter shall be construed. That phrase right there is the beginning and the end of it. As we move on, it gets complex, and I think that has confused people because of how long the statute is. It's 165 words long. It has 3 Roman numerals and 2 numbers. The Gettysburg Address, I think, was 270 words long. So that's how long the statute is. So when you get all that terminology, all that very specific insurance terminology mixed in there, you kind of lose sight of the active part of the statute, which is nothing contained in the insurance chapter shall be construed, and then provided that this is not true, which means the opposite. Then the other provisions in the insurance code should be construed then to prohibit cost containment measures. And that's really it. And that's all this court is here today to do, is say, what does 514F2 mean? And because it doesn't mean anything by itself, because it just tells the court what other insurance statutes mean, that's all this court needs to say, and then that's the end of the matter. There are other statutes that came in the same House File 2219, which unambiguously talk about insurance coverage. They use this same phraseology, limit or make optional payment or reimbursement based upon licensure. And as you read those statutes, 509.3, for example, is one, again, unambiguously talks about this is coverage. We are talking about the relationship between the insured and the insurance company. And that is, it's not insignificant for chiropractors. It's very significant for chiropractors because it is what's called an optional mandate. It requires companies like Wellmark to cover chiropractic services in certain circumstances. If they cover, for example, some manipulation that a DO can do, then it says, well, then if you're doing that, then you should provide coverage for all manipulation services regardless of the license. That, of course, gets chiropractors more patience. So it's not as if that statute is nothing. The chiropractors undoubtedly pushed for it. They wanted for it. They wanted it. It came after Judge Stewart's ruling.
This seems like you're making a lot about kind of the placement of the provided that language. I mean, if I tell my son, I'm not saying you can't play with the Xbox when you get home, provided you take out the trash, he has to take the trash out.
Or he can't play with the Xbox.
Or, whether he uses the Xbox or not. I mean, that might be my interpretation. I understand where you're coming from, but it does seem like you have pretty direct language after the provided that imposes a fairly direct requirement. And wouldn't it be logical that the legislature would do that? They've already said you have to cover chiropractic services, and it would seem to me that you would defeat the coverage, you could defeat the coverage requirement or circumvent the coverage requirement very easily if you could cover those services but simply pay the chiropractors 10 cents on the offer to pay them 10 cents on the dollar. The result would be policyholders would not get coverage because no chiropractors would belong to the network. I mean, doesn't that kind of make sense?
No, there's a network adequacy requirement too in the code, which says you have to have enough chiropractors in your PPO, for example, to cover certain services. So that's already taken care of. I think it was just kind of a belt and suspenders approach. And as Mr. Norris said, the chiropractors wanted this provision at the end. And I think they wanted it because they felt that they were worried that using utilization systems could somehow limit or make optional coverage. And that phrase, limit or make optional payment or reimbursement, those are coverage words. We don't talk about fixing the prices or taking away the power of an insurance company to negotiate lower prices with that kind of language, payment or reimbursement. Payment, for example, is qualified by make optional. That makes no sense if we're talking about a provider agreement, because the provider agreement says you will cover our patients for this service. And so from the insured's perspective, they get covered no matter what. They're great, they're good. If we're talking about, really about the provider agreement, about coverage, make optional payment makes no sense. The insurance company would never have the option to pay. But the phrase, make payment optional, makes complete sense when you see it as the legislature was using that in terms of coverage. And you see that in the amendments to the statute, in which certain legislators said, no, wait, I think we do want to give covered individuals or their plans the option to exclude the coverage so long as they write it out.
Well,
And that's all that was
Counsel,
about.
I think your interpretation or construction of the word optional may have some purchase with me, but what is your view about the legislature's interpretation or meaning for the word limit under your assessment of the statute?
Right, well, when you read it as a whole, you see all of this is about coverage. And actually, if you look at limit in isolation, I mean, it is a strange word to use when really you say pay the same as. I mean, we talk about coverage limits. We don't talk about payment limits, meaning I'm negotiating with you and I'm going to negotiate my fees with my lawyer. I'm going to limit his payment. Or we don't talk about discrimination cases, for example. When somebody comes into the office, they don't say, you know, a woman doesn't come in and say, they say, I was paid less than this person, or I was discriminated against. They don't say, my pay was limited. Limit is a coverage word, not a word that we talk about when negotiating fee schedules between insurance companies and chiropractors. And no court has held, no state has used that kind of phraseology to actually require insurance companies to pay more than what the physicians were willing to accept. Because that's a very serious thing that we're doing here, right? Is we're saying we better be very certain that that's what the legislature intended to do. Because what's happening is that the chiropractors are willing to accept less. And if we thought that the legislature wanted insurers to pay more, we better make sure that the language is exactly that. The only other state that has this language that Iowa has, this limit or make optional reimbursement, is South Dakota. In 1992, they borrowed our same language. Their insurance commissioner has ruled the exact same way. It refers to coverage.
What then, in your view, was the legislature contemplating in terms of limiting coverage, the prohibition on limiting coverage?
Yeah, absolutely. And we actually have examples of that because in the record, because we do have self-funded plans that are ERISA preempted, so they can limit coverage. And what that means is they can say, for example, you only can go to a chiropractor 10 times a year. That's it, no more, never. That's a limit. It's not making it optional, meaning not covering at all. It's saying we're covering it to a certain extent, but we're limiting chiropractic coverage. That's what limit means in this context. In the dental insurance case that Justice Mansfield wrote, we have an exact example of what the legislature does when it really wants to regulate the contracts between the providers and the insurance companies. It is very specific. In that case, they are very specific about, we want to regulate this contract between them. You do not have that here. And in fact, that opinion only further reinforces the idea, because here we use the word reimbursement, and reimbursement is to pay back. And so if you're talking about that as a coverage word, it makes complete sense, because if you're going out of network, you pay for your chiropractic coverages, then the insurance company reimburses the patient. They don't reimburse. No one ever reimburses the physicians for that. The payment happens when it's direct, of course, when it's through the provider agreement. I see that I have already blown through my 10 minutes, so if there are no further questions, I will sit down. Thank you.
Thank you very much, Counsel. Could you put 5 minutes on?
Thank you. May it please the court. I think Mr. Koopmans did a good job talking about the interpretation of the statute, and so I thought I'd talk a little bit about the role of the insurance division and how really the insurance division's role shows a little bit more why this statute doesn't mean what the appellants want it to. Essentially, they wanted to come to the insurance commissioner and ask him to say that their contracts with Wellmark were invalid according to the statute, and in fact that Wellmark would be required to pay them more. They wanted the commissioner to say that. The insurance division's role is limited by statute. They don't have any common law authority. They don't have any general authority. They only have the authority that the legislature specifically gives them. The insurance division regulates the insurance industry for the protection of consumers, and they do this in a lot of different ways. They regulate rates to make sure they're not too low where the company would become insolvent, or that they're not excessive. They have the power to do that. They also have the power to take complaints from consumers about insurance practices. The commissioner can, if he believes that a licensee, a insurer, or an insurance agent has committed some kind of unfair act that violates some restriction in the Iowa Code, he has the power to file charges and to have an administrative hearing on that. And that is when a contested case would come into being. The commissioner has the authority to take away some entitlement, the ability to sell or produce insurance in the state of Iowa. And so in that case, these constitutional provisions that the appellants were bringing up in their brief would come to play. But the insurance division doesn't have and isn't given by statute any ability to serve as a private claims court. I think appellants talked about this as analogous to a breach of contract action, and I think that's right. Their dispute is with the person they're contracting with. The insurance commissioner doesn't have any authority to decipher that, to decide who's right and who's wrong, or issue damages. It's analogous to other licensing agencies in that way. The Board of Medicine, for example, disciplines physicians if they've committed some kind of act that's outside the standard of care. They don't hear malpractice cases. That's something that happens in the civil court.
Basically, what you're saying is that they have no avenue through the insurance commissioner to do this. So what is...
Right.
what
Not
is
the avenue they chose, what they want
What
to
is
have
the
happen.
appropriate avenue then for chiropractors if they feel like they're being discriminated against based upon the statute that says you can't be discriminated against based upon the mere licensure?
Well,
What's
sure. So the
what's
insurance
avenue
commission...
for them
Sorry.
to come before anybody or any tribunal then?
Sure. Well, the insurance commissioner set forth in his order that as he interpreted the statute, the statute actually doesn't provide that they can't be discriminated against in payment. And as I said before, I think the insurance commissioner only has the power granted by statute. And if the legislature wanted to say, you have the power to determine not only rates that consumers are charged, but how much insurance companies pay their provider, they would have done so a lot more clearly. And so the insurance commissioner's conclusion when reading the statute is first that it was simply advisory. And even if you concluded that it had some kind of regulatory impact, that only had to do with coverage, which was the sense of the whole of all the provisions dealing with chiropractic care.
So the only real remedy, it sounds like you're telling me, is if the legislature changes the statute and makes some provision like that.
Sure, or if they were to
authorizes that.
negotiate with Wellmark to get a deal that they like Wellmark for breach of contract. I think there's a lot of remedies that they could seek outside of the insurance division, but that's not something the insurance division would be empowered to do for them.
In our first Mueller case, did we send them on a wild goose chase by saying you don't have a private right of action to sue directly for a violation of 514F.2, go to the insurance commissioner?
So I think what that means is that they can go to the insurance commissioner and file a complaint. Anybody can do that. And that would start the process in the division to look at whether anybody has committed any kind of unfair trade practice. And essentially that's what the commissioner converted this into, was you've made a complaint, and we're not acting on that because we don't think anything's gone wrong, and I'm going to talk about this in terms of interpreting the statute. And anybody can ask for a deck action, so that's why he treated it like that.
But as you said, you're not a private claims collection court.
No, so when he saw that the dispute was essentially, we think we should be paid more, that's not something we have the power to do for them under the limited authority granted by the statute.
As you interpret that provision.
As the commissioner interpreted the statute.
And what deference should we give to the commissioner's interpretation?
Oh, thank you. I know that came up earlier. I think the commissioner should be granted deference. He does have rulemaking authority. He has the authority over this entire section of statutes called the Insurance Code. He does have specialized knowledge. That's why he's called to the position and appointed by the governor. But I think the district court was right that even if you look at it for errors of law, his interpretation was correct.
But did the Iowa legislature ever use the word power to interpret, or give them expressly say he has interpretive authority?
I don't think the legislature used those words in the statute, no. It just said they had rulemaking authority.
And since Renda, have we ever held that the insurance commissioner had interpretive authority?
that the insurance commissioner specifically, not that I know of, no, thank you. Okay, I'm almost out of time. I wanted to, something came up while I was preparing today. The appellants referred to a Supreme Court case which talked about, it was called Group Life and Health Insurance Co. versus Royal Drug Company from 1979. And that case was about whether the provider arrangements between an insurance company and a provider, in this case a pharmacy, were part of the antitrust exemption for insurance business, and the court said it wasn't. And they kind of included some language that is relevant to understanding the kind of different ways these parties viewed this dispute. It said the fallacy of the petitioner's position is that they confuse the obligations of Blue Shield under its insurance policies, which insure against the risk that policyholders will be unable to pay for prescription drugs, and the agreements between Blue Shield and the participating pharmacies, which serve only to minimize the costs that Blue Shield incurs in fulfilling its underwriting obligations. And so this is not about insurance, which is what the insurance division regulates. This is about the arrangements that Wellmark has made so that it can fill its obligations to its insureds. And how it does that has never really been the concern of the insurance division. So thank you. It looks like I'm out of time. Oh, I have 2 minutes. I forgot.
Oh, no, it's running the other way.
It's running the other way.
You're 2 minutes late.
I'm 2 minutes late. Oh, thank you.
Thank you, Ms. Esbrook. Rebuttal, Mr. Norris?
May I go to the board again here? I don't think there's any question that this first part has to do with systems between an insurance company or other, like Evans, and providers. It just can't be anything else. It doesn't have anything to do with coverage whatsoever. So whoever drafted the provider part about coverage, I don't think he was saying. Now, here is the phrase. Do not leave, provided these systems do not limit or make optional payment or reimbursement for healthcare services on a basis of blah, blah, blah. Well, make optional, I can't tell you exactly how they can make it optional. But if they do, and it's discriminatory to chiropractors, they don't have any authority to do these things. Limit clearly does have to do with paying less. Now, the only other issue here is payment or reimbursement. And Mr. Koopmans, good lawyer, said, well, reimbursement has to do with coverage, because that has to do with the basic insurance contract with the beneficiary, which is basically a reimbursement for loss. That's what insurance is. I say no, that's not right. That's not how it reads here, because you've got two situations in a preferred provider situation. You have the people who are the preferred providers, and the beneficiaries get a break on the deductible, one way or the other, for those people. Now, if they aren't a preferred provider, the coverage is still there, but it is insurance type coverage, and basically it's a reimbursement to the beneficiary, and it's the responsibility of the beneficiary then to pay the provider. Now, there's a part in Wellmark's brief, and I don't have it handy to tell you where it is, but there's about a page where they say precisely that's what a preferred provider contract is. And if you read that against this, it tells you the answer to what that's talking about. It's talking about systems. These are the systems. They are not benefits to insureds. They are contracts with providers. I don't know which way I am, but I'm going to thank you. Thank you very much.
Thank you as well, Mr. Norris.
Right.
Case of Abbas and others versus Iowa Insurance Division and Wellmark is now then submitted to the court, and we'll next hear arguments in State versus Ramirez.